The black robe is designed to intimidate, but it hides a secret. The person wearing it is a bonded contractor, and their authority ends where your rights begin. It is a common experience in the modern courtroom to feel a sense of total helplessness. When a judge denies a motion without merit, bars entry to a public hearing, or bans cell phones to prevent the recording of their conduct, they are acting as policy enforcers rather than impartial arbiters of law. However, this appearance of monarch-like power is a carefully maintained illusion. In reality, these officials are not sovereign rulers. They are bonded administrators. Behind the bench lies a financial insurance policy, a surety bond. These bonds are the ultimate kill switch for administrative tyranny. When an official violates their oath, they aren't just breaking a rule. They are committing a breach of trust that triggers their personal and professional financial liability. The fundamental shift in power begins with understanding that under 63 CAM Jur 2D, American Jurisprudence, 2nd edition, all public officials are legally trustees of the American people. They do not hold power over you. They hold the public's trust in a fiduciary capacity for your benefit. Furthermore, under 15 U.S.C. Section 3215A, the United States is defined as a federal corporation, making every state a subsidiary corporation. The people sitting on the bench are agents of a corporate entity, not the masters of the republic. When an official takes an oath, they enter a contract to protect the constitutional rights of the beneficiaries, the people. Any deviation from this is a mixed war against the Constitution. I do solemnly swear or affirm that I will support, protect, defend the Constitution of the United States and the Constitution of the State of Indiana, and that I will discharge the duties of my office with fidelity. Viewing officials as trustees replaces the status of subject with that of beneficiary. If they fail to support, protect, and defend, they have breached the trust. You are the overseer. They are the employee.
You have the right to be secure in your person and property. Why is that important? Because a cop cannot arrest you on a warrant for witness of saying through information or something to effect like that. They can't just arrest you and they say, we're going to prove it later. That violates your freedom. It violates your security of your person because they run you into the shop. They steal your fingerprint. They take your fingerprint. They take your photo ID, your mug shot. They take that image and they steal that from you. But you have the right to be secure in your person and property. What is property? Everybody thinks that's land or house or truck or whatever. No, under the Constitution of 1776, your property is your unalienable rights. That's your property. You own that. It's not given to you by a government. It's not given to you by a constitution. It's not given to you by anything other than Yahuwah. Yahuwah gave you those unalienable rights. And you have the right to defend those rights. And you have the right to bear arms to do it if necessary, with whatever means necessary. So when they arrest you without due process of a grand jury, which is a grand jury of 16 of your peers, 23 altogether, 7 alternates, that court that thinks it has jurisdiction over you must prove you harmed somebody to get permission to indict you, to override your unalienable rights. No fucking judge anywhere in this country has the authority to do that. Not one. They are all liars, corrupt criminals. Now, these fucking attorneys will tell you, well, he can do that because of the modern living constitution and the state statutes, the state's codes. Marbury versus Madison. No state shall make a law unless upon agreement to the United States Constitution, 1803.
Locating a public official's surety bond is the first step in holding them accountable. In Indiana, for example, Indiana Code IC 54118 mandates that specific officials must file and maintain an individual surety bond to remain in office. This includes city judges, controllers, clerks, and town judges. If they are not bonded, their office is legally vacant, and they are acting without authority. To unearth these documents, you must use the Freedom of Information Act, FOIA, and state-specific transparency laws. Our research into the paper trail shows that many of these bonds are backed by the Ohio Casualty Insurance Company, a corporation organized under the laws of New Hampshire but operating out of Pennsylvania. The disclosure timeline. Written requests. Per 5 U.S.C. Section 552, FOIA, and the Indiana Access to Public Records Act, IC 51431, officials are obligated to supply bond information within 7 business days. In-person requests. For maximum tactical pressure, making the request in person triggers a 24-hour mandatory disclosure requirement.
Says at the top, this letter is a citizen's demand to cease and desist the unconstitutional practice of administrative adjudications. All administrative agencies, whether in the executive, judicial, or legislative branch, have been stripped of authority to adjudicate the private rights of citizens by the United States Supreme Court. Further, this letter serves as a public records request for the docket, registry, or report of all open cases pending under your administration, under your authority, under your administrative court, or under the administrative process in any manner. I appreciate your response in 10 days from this date, September the 6th, 2024. The next paragraph says, demand is made under the authority of the Tennessee Constitution, Article 1, Section 1. It says that all power is inherent in the people, and all free governments are founded on their authority. Their meaning the people, not the government. Their, see that word right there? Their authority is not the government, it's the people. And instituted for their, see that there over here? Their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable, right? You see that right there? Unalienable and indefeasible right to alter, reform, or abolish their government in such manner as they, you see that they right there? That's the people. It's not the other guys. It's not the government.
A common tactic used by officials to evade liability is the use of misnomers or fictitious names. You will often see Honorable Judge name or names with missing middle initials on court documents. This is a clear violation of Title VI CFR 73.3, which requires the use of a full legal name. Using a fictitious or doing business as DBA name without proper registration to conduct official business is more than a clerical error. It is a potential violation of Title 18 U.S.C. 1342, which involves using a fictitious name to conduct fraudulent activity. Furthermore, Federal Rules of Civil Procedure, FRCP, Rule 11B, and the Real ID Act require agents working on behalf of a principal to be fully compliant and transparent in their identity. When you find the bond, you may notice small amounts, such as a $15,000 bond for a judge. However, we have observed that the clerk of the court often carries a much larger bond, frequently $300,000. Based on the standard logic of bail bonds, where you pay 10% of the total, it is a high probability theory that the listed bond amount represents only 10% of the actual liability policy. Thus, a $300,000 bond may actually represent a $3 million insurance policy. If your claim for damages exceeds the bond amount, you must move to liquidate the estate. You can compel the official to fill out IRS Form 433A, Collection Information Statement for wage earners and self-employed individuals, and IRS Form 433B, Collection Information Statement for businesses. These forms are used to identify and target their personal and business assets to ensure the victim is made whole after a breach of trust. The ultimate nuclear option is collapsing the bond. This involves filing a claim directly with a surety, like the Ohio Casualty Insurance Company, and providing evidence of the official's breach of trust. The consequences of a collapsed bond. Unbondability. Once an official has a claim paid out against them for a breach of trust, they become unbondable. Immediate vacancy. Because being bonded is a statutory requirement for holding office, an unbondable official is legally barred from their position, effectively vacating the office. If local law enforcement is complicit in the official's mixed war, you have a final recourse: the sheriff's inquiry. If a sheriff refuses to investigate criminal public officials, the county coroner, and only the coroner, has the statutory authority to arrest the sheriff. This is the fail-safe designed to prevent a total collapse of accountability in a community. Restoring due process is not achieved through pleading. It is achieved through meticulous documentation and the aggressive application of administrative law. When you stop viewing officials as untouchable and start viewing them as bonded contractors operating within a corporate system, the power dynamic shifts in your favor. The path to accountability requires you to perform your own due diligence. Will you continue to treat your local officials as masters of the law, or will you treat them as the strictly liable, bonded employees they truly are? Take a moment to read this letter over from the Acting Solicitor General. The powers that were are losing their immunity from the higher courts. Everyone has had enough. The Department of Justice won't defend anything they do pertaining to violating people's constitutional rights and freedoms in the administrative courts anymore.